Hello and welcome to the Our Prenup Lawyer podcast, where you and I get to learn more about prenups as I interview professionals from the fields of family law, couples counseling, and wealth management. I'm your host, Libby Garabedian. Let's get started. The information provided in this podcast is prepared by Our Prenup Lawyer for informational purposes only and does not constitute legal advice. The information is not intended to create an attorney-client relationship. This is not legal advice or a substitute for obtaining legal advice from an attorney. A person listening or watching should not rely upon it in any manner without engaging professional counsel. The podcast is intended to communicate general information and, because recorded, may not be current. On this episode of Our Prenup Lawyer podcast, I'm joined by Tyler Summers, a Massachusetts family law attorney who helps clients navigate life's most difficult transitions with clarity, compassion, and strategic insight. His firm has offices in both Boston and Needham, and Tyler focuses on high net worth prenuptial agreements and divorces, bringing together precise legal work with an understanding of the personal dynamics at play. He has earned recognition from his peers and clients alike, including a superb Avvo rating, the American Institute of Family Law Attorneys' top 10 best attorneys for client satisfaction, and designation of super lawyer every year since 2017. Before founding his practice in 2015, Tyler sharpened his litigation skills as a prominent domestic relations firm and through clerkship in Massachusetts trial courts, including work on high-profile federal cases that require both discretion and strategy. He's a graduate of NYU and Suffolk University's law school and is admitted to practice in all Massachusetts state and federal courts. Beyond the courtroom, Tyler has built a strong presence on social media with nearly 50,000 followers on Instagram at Boston Family Lawyer. Welcome, Tyler. Thank you for being on the podcast.
It's great to be here.
Well, I want to get started and ask you about your career in family law. What drew you to this field?
Sure. Well, I knew from a young age that I always wanted to be a lawyer. In fact, there's a picture of me when I must have been 6 months old, and my mother and father had a bib that said future lawyer. So I guess I was always set out for this type of work. Now, family law. When I went to law school, I knew I wanted to be in court. I knew I wanted to make arguments and try cases. And family law is an area of the law where people find themselves in court quite a bit. There's a lot of oral advocacy involved in family law. Criminal law is another field where you get to be in court quite a bit. Now, I could have gone a more corporate route, big law, corporate law, big law firms, and frankly, I may have made more money when I was starting out had I gone that route, but I like working with people. I don't want to work with companies. I want to work with people. I want to help solve real problems for people. Help them get from point A to point B in the most efficient and peaceful way possible.
That's wonderful that you're so people-centered. So what services do you offer at your practice?
So my practice is entirely focused in family law. Everything from before the marriage, prenups, to issues during the marriage. Perhaps we would do a postnup during the marriage. And then, of course, everything related to the dissolution of a marriage. Contested divorce litigation, out-of-court settlement negotiations. I see it all.
Okay. And what's your philosophy when it comes to divorce? Is your instinct always to litigate, or do you ever do mediation?
Sure. So my instinct is that litigation needs to be a last resort. Court should be a last resort. If you can reach agreement without involving a judge, far more efficient, both in terms of time and in terms of cost. So when there's an ability to agree on something, I always encourage my clients to make that agreement. Now, some things just cannot be agreed to. And some divorces and some family law matters need to go to court. And if I, as someone who's been doing this for 12, 13, almost 14 years at this point, I can tell when a case needs to go to court or when there's hope of resolving it outside of the courtroom.
So how does the separation process look different when there's a prenup in place?
Well, 95% of the time, I'm thrilled as a divorce attorney when a client comes to me and tells me that they have a prenup. Now, why am I thrilled about that? Well, I'm thrilled because most likely this prenup is going to dictate the process that I, as the divorce attorney, need to follow. It's work that's already been agreed to by the parties.
Okay, so I want to shift gears and talk about your drafting process for prenups. What does that look like when you have a client come to you?
Sure. So, like I said, a huge part of my portion involves both drafting and reviewing of prenups. Just last year, I negotiated approximately 40 prenups, and I think the year prior may have actually been a little higher. So, this is a huge part of my practice. I'm often on the drafting side, and I'm also as frequently as often on the reviewing side. When it comes to drafting, oftentimes the fiance that is proposing that a draft be put together is the fiance that is looking for some sort of protection in this prenup. So when they come to me for drafting, it's usually because they're coming into the marriage with significant wealth, or alternatively, they may be inheriting significant wealth during the marriage. So what does the drafting process looks like? Well, it begins with an initial meeting. I want to learn all about this person. I want to learn about their family. I want to learn about how they may decide to commingle and combine finances with their soon to be husband or wife. Really got to get to know the person. From there, I can start making recommendations about how this document should be structured.
In getting to know the person that you're working with, what are common clauses or statutory calculations that you recommend as must-haves in their prenup?
Sure. So it's always important to explain to clients, both on the drafting side and the reviewing side, what the underlying default law is in your state. If you do not understand how marriage and divorce works under our default laws, then you're not going to be able to understand the prenup. So that's point A. What does our law say about how assets and debts are divided in the event of divorce? And we also talk about how our state thinks about alimony, also known as spousal support.
Do you ever run into situations where a client or a prenup you're reviewing has a lifestyle provision or other calculation that is egregious in nature?
I've had many requests over the years for these so-called lifestyle provisions, meaning penalties if there's cheating, an infidelity clause, we oftentimes called it. I've had requests for limits on how much the mother-in-law can come visit during a calendar year. I've had requests demanding that if someone's body weight goes over a certain number, that may trigger some sort of penalty. I steer clear of all of these lifestyle clauses. I do not believe they're enforceable, and frankly, they put a really bad taste in my mouth. You should be focusing in a prenup on financials. You should not be focusing on cheating, your mother-in-law, your body weight. Stick to the numbers.
So, before we get into talking more about the financials and estate planning, how do you see couples resolve these issues when, let's say, there is a mother-in-law or infidelity clause and they want these very unique terms in their prenup, but you don't think they're feasible?
Sure. Well, that won't be the client for me. Oftentimes, these requests are made during an initial consultation, and I'll be very clear that I'm not going to draft or include those types of provisions, so I may not be the right fit. And frankly, these lifestyle provisions, I think, have less to do with the law or legal advice, and frankly, far more to do with psychology, social work. Maybe this couple needs to go sit down with a counselor.
That's a good perspective you offer on that. So, have you ever run into a situation where someone presented your client with a take it or leave it prenup and you told them it's time to walk away?
Yes. Oftentimes, when we're dealing with someone who has massive wealth, I'm talking hundreds of millions of dollars, and I've seen quite a few prenups involving that level of wealth. Oftentimes, we are dealing with a law firm that says, these are the terms, you take it or you leave it. The rationale for that is that there's usually, extreme family wealth, perhaps a business, and in order to keep that business intact, we really need a cutthroat prenup. So if I don't think it's fair, what I do is I tell my client that. I write my client a letter. I tell them via email that these terms are frankly lopsided, one-sided, and unfair. If we push back and the other side still says no, then my client has a choice to make. Just because I tell a client that a prenup is unfair, that doesn't mean that the client won't necessarily sign it. Many clients over the years, for better or worse, they have signed prenups that I've advised against signing. They're proceeding at their own risk. As their counselor, my responsibility is to tell them what those risks are.
Okay. So when thinking about generational wealth and let's say the bank of mom and dad, when that's on your side and you're drafting the prenup or you're reviewing it, how do your processes look different to keep your client in mind?
Sure. Well, when dealing with the bank of mom or dad, I do want to say oftentimes the first call that my office gets is from mom or dad. There have even been instances where grandma or grandpa is calling me. I really don't like that. I want to work directly with the fiance, the party who is getting married. I appreciate that mom, dad, grandma, and grandpa want to be helpful and frankly want to protect their wealth, but this isn't their marriage. This is their child's marriage. This is their grandchild's marriage. If you're old enough to walk down the aisle and say I do and sign a marriage license, I think you're mature and old enough to give me, a lawyer, a call about your prenup.
So how do you keep the process autonomous for your client when you've got these third parties trying to insert their influence?
Yeah, well, I make sure that my client knows that this is his or her prenup. It's not their mom or dad's prenup. And that the client is the fiance. It's not mom or dad. So sometimes boundaries are crossed, and I do need to step in and make sure that there are some boundaries in place.
So when should couples start discussing prenups?
As soon as possible. The earlier, the better. Way too many people, Libby, are only thinking about the prenup a month or so before the wedding. And while you can get a prenup together in a few weeks or a month, it's certainly stressful. You certainly need to be engaged. And frankly, when you're in the days before your wedding, do you want to be dealing with a lawyer? Wouldn't you rather be dealing with the florist or the caterer or your out-of-town guests? So my advice is the earlier, the better.
How can estate planning be done in conjunction with the prenup?
Sure. So there's a misconception out there that a prenup is only going to address divorce. And primarily, a prenup is a divorce tool. But there are certain death-related rights that you obtain when you become legally married. For example, if you're married to someone and that person doesn't have a will, first in line to collect is the surviving spouse. Most people don't realize that. That is a right that can be addressed in a prenup. Another right you obtain when you become legally married to someone with regard to death has to do with their will. So let's say your husband has a will, but your husband left you nothing in his will. Well, our society doesn't think that's appropriate. So as the surviving spouse, you can actually go to court and elect against, that's the expression we use, you can elect against your deceased spouse's will. So when you don't address death in a prenup, there are ways to counteract what your spouse's wishes were in their will. In a prenup, we can say that whatever the spouse says in his or her will is going to be respected, and the surviving spouse under no circumstance would elect against the terms that were provided for in that will. Sometimes we address death in a prenup and sometimes we don't. I'd say when I'm dealing with people who are a little older in life, Libby, when I'm dealing with people who are in their second or third marriage, addressing death in a prenup does oftentimes make more sense than not addressing it. But I want to be clear that a prenup is not a substitute for a comprehensive estate plan. You still need a will. You still potentially need a trust. You still should have a healthcare proxy. You still should have a power of attorney. There are lots of things that are not going to be addressed in a prenup regarding death that should absolutely be addressed at some point after you walk down the aisle.
Okay, so going back onto what you touched on about a prenup for a couple in their second or third marriage, how do those prenups differ from a couple in their first marriage?
Sure. Well, second or third marriage prenups often differ because there may be kids. There may be kids from that pre-existing relationship, and we perhaps want to ensure that there's going to be money available for those children from the pre-existing relationship. So that's a dynamic that we wouldn't see in a first marriage prenup. Another thing that we would often see in a second or third marriage prenup is perhaps we are going to be more in depth when it comes to death and estate planning because you're that much closer to death.
Okay. Now, with these second or third marriage prenups, oftentimes there's one spouse or both spouses have acquired greater assets, they have more wealth, or even they have a business that's taken off. Now, when you have higher earners like that, and maybe you're on the side of the lesser earning spouse, how do you equalize the marriage in that prenup?
Well, I don't think the goal is equalization. If the goal is equalization, then we probably do not need a prenup.
Okay. Okay. So, if you have an individual who has decided that after they're married, that their spouse is going to stay at home and take care of the kids and contribute completely domestically to the relationship, how do you protect that spouse so that if there is a divorce, they have something in the future to fall back on?
You have no idea the amount of calls I get from people who are in their early 20s who say they want a prenup where everything is separate and they never have to pay alimony or spousal support to the other party under any circumstance. And then I say to them, well, what if you step away from the workforce for childcare to be a stay-at-home mom or be a stay-at-home dad? Oh, that'll never happen. That'll never happen. That's what people in their early 20s are truly convinced of. Now, as someone who's almost 40, I can tell you that the thinking behind becoming a stay-at-home mom or becoming a stay-at-home dad evolves. So when it may have never seemed like a possibility when you were 23, I can assure you when you're 38, it may very well be a possibility. So ideally, we want a prenup that's not only going to make sense based on our circumstances today, but is also going to make sense in the future as circumstances change, and they will change.
Okay. That's good to keep in mind. So as your relationship, you have to so for clients, they have to keep in mind that as their relationship evolves, personal things about themselves evolve. So it's important to have a roadmap or a safety net for their future.
Correct. And some people I counsel, Libby, who are in their early 20s, who say they're never going to be a stay-at-home parent, I'm very clear, and I put this in writing. If you are going to step away from the workforce, you need to re-examine this prenup. Perhaps we need to do a postnup because you stepping away from the workforce while your spouse continues to earn could be devastating in the long run.
Okay, so what are common provisions that you deal with in postnups when the couple has decided it's time to have something that can guide the rest of their marriage?
Sure. So it depends on the circumstances. Let's say these parties got married in their early 20s and maybe they had a very strict prenup that had a lot of separation. What's mine is mine, what's hers is hers. If we have anything in joint name, we'll divide that. But otherwise, there'll be no division and we'll never pay alimony. Maybe now they're now in their mid 30s. They have kids on the way. They need to re-examine those terms and they need to have a much fairer postnup where one spouse earns, that spouse doesn't get to keep it all to him or herself. We'd also need to re-examine the possibility of alimony.
Okay. Now, what advice would you give to an engaged couple that's considering whether or not to get a prenup?
My advice is you should absolutely consider the pros and cons of getting a prenup. And frankly, the pros far outweigh, in my opinion, maybe I'm biased, but they far outweigh any con. Having these open communications about money, about lifestyle. Most engaged couples never talk about these things until it's way too late, until they're at the other end of the marriage, they're getting divorced, they're at each other's throats. It's much easier to have conversations about money and lifestyle preferences when you're in a good place before the marriage. So I strongly encourage any engaged couple to at least explore the possibility of a prenup and how it may be able to, frankly, enhance their relationship. I can tell you that couples that successfully navigate a prenup process, there's a far greater likelihood that they're going to have a successful marriage. And I can tell you, having done hundreds of prenups over the years, I can tell during the negotiation process when perhaps the foundation of this relationship is not strong.
So what are some red flags if during the negotiation process, but also before, if there's a couple where one spouse is not willing to have these difficult or money conversations?
That in and of itself is the red flag. If you're engaged to someone and they're not willing to have difficult conversations about money, about finances, about budgeting, about lifestyle, if they're not willing to engage on those topics, I'm not sure that that's a strong relationship, and that I probably would say don't marry that person.
What do you think is key to having a successful marriage?
Communication, communication, communication. In my divorce work, looking at all the failed relationships that I've seen over the years and that I see every day, the primary issue is that they've lost any ability to communicate.
Well, I want to thank you for your time. And I want to ask you, if listeners are interested in reaching out to you, what's the best way to contact you?
I would love to speak to your listeners, Livy. The best way to contact me is through my website. Also, you can find contact information on my Instagram account. I'm also on LinkedIn. Happy to speak with anyone all over the country. That said, I am only licensed to practice in Massachusetts. So if I can be helpful with a prenup or a family law matter, you would need to be in Massachusetts or have some sort of connection for Massachusetts for me to be the appropriate counsel. However, I know attorneys all over the country, so I can be a resource to your listeners who are outside of Massachusetts.
Excellent. Thank you. And we will have your website in the show notes so people can access it from there. Thank you so much for being on the podcast.
It was a pleasure to be here.
That's our show, folks. Thank you for listening to Our Prenup Lawyer. Make sure to like and subscribe, and feel free to drop a comment below. Follow us on Instagram at Our Prenup Lawyer, and listen to us on Spotify, iHeart, Apple Podcasts, Audible, and watch us on YouTube. See you guys next time.